Welcome once again to Lehto's Law. Here's Steve Lehto.
HOAs are one of those organizations that when I talk about them gets people all fired up. And so several people sent me a story. So Steve, check the story out of North Carolina by Joe Fisher, WRAL reporter at WRAL.com. HOA homeowner in court over snacks for dogs. Yeah, there's a fight going on, and at the center of this is a guy who wants to put snacks out for dogs. And the HOA says you can't do that. So we'll talk about this. A Raleigh man created a dog treat station outside his home as an act of kindness. And he never expected to find himself in the middle of a lawsuit in Wake County District Court. The HOA of his neighborhood wants that dog treat station moved, but he says he's not taking it down without a fight. The pet snack station sits in the grassy area between the sidewalk and the street. So this is one of those neighborhoods where there's homes, yards, sidewalk, and a street. Between the sidewalk and the street is apparently a grassy area. The man loves keeping dog treats well stocked outside his home in Bedford at Falls River. Now he's asking a judge to answer the question, does the HOA have the authority to tell him what he can and cannot do with his piece of land? I put these items in place so dogs could come by for a drink of water or a snack, he says. The water bowl, treats, and figurines have become a big hit with neighbors, as evidenced by all the activity there. He says, I've never personally received any complaint from any homeowner. However, apparently he got a complaint from the HOA. The Bedford at Falls River HOA says the snack station's placement is in the city's right-of-way, which it contends it controls under the community's restrictive covenants. The snack station has been there for 5 years, but the man says the HOA didn't get involved until 2020. First, they sent him written warnings, which he didn't respond to apparently, and he says they eventually threatened to fine him $100 a day. Now he says, I think they're overreaching their authority. I think the board has taken it upon themselves to decide that they have control over this when in fact we don't believe that they do have control over it. So he hopes a judge can clear it up. Now his lawsuit claims the HOA's own rules state that property owned by the city or within the right-of-way is exempt from HOA control. I've talked about this recently, and I got to be very careful about this because some people get very upset. But you can own property, and then there might be an easement over the property, for instance, for a road or for a sidewalk. And quite often, when they do put in a road, even though you own the property underneath the road creates an easement that people can drive on and quite often is maintained by the city, the township, whoever. Someone else maintains it. And they often say, along with that easement, we've got a right-of-way in a little ways also. And so that's why we've talked before about mailboxes, for instance, whether they're in the right-of-way next to the road. So the question is, the HOA's rules apparently say that they do not control property owned by the city, but the city wouldn't own that property. But within the right-of-way, that's a question, because that could be the right-of-way for the city. In his lawsuit, he argues that to the extent there is an ambiguity in the language of the restrictive covenants, the language is to be strictly construed in favor of the free use of the land. And when you talk about how you read a contract and enforce a contract, they often talk about ambiguity. So if somebody drafts a contract and the other side signs it, and there's ambiguity in there, meaning there's literally something can be read two different ways, they will often say that the ambiguity is construed against the drafter. If it's for or against one party's going to win or lose. Well, the ambiguity, it's like a tie goes to the runner. The ambiguity goes to the other side, okay? But the attorney representing the HOA argues the association has the authority to enforce provisions of the covenants, including the pet snack station, placed upon any portion of the properties in order to preserve and protect the common plan and scheme of the development. The attorney representing the HOA reiterates the desire, simply asking the man to move his snack station a few feet onto his own front lawn. So they're saying, look, all we have a problem with is which side of the sidewalk it's on. That's what they're saying. The association is simply requesting the man move his snack station to property he owns, We're trying to keep the neighborhood consistent and maintain property values, says the attorney representing the Bedford at Falls River HOA and the neighborhood's former property management company, Professional Properties Management of Raleigh. Now, the man with the snack station says the HOA eventually agreed to allow pet snack stations on front lawns instead of the right-of-way, and one of his neighbors has one down the street. However, the man says the things on his snack station would not fit in his front yard and could create a tripping hazard. I'm not quite sure what he's getting at there, but he says he's not budging. Apparently, now it's a matter of principle. So for now, the four-legged visitors keep coming by and enjoying his snacks until the court straightens this out. The man has spent thousands of dollars in legal fees. He hopes to recoup that money if he wins. Right now, both sides are awaiting the court's decision on who has authority over that strip of land between the sidewalk and the road. So HOAs are one of, like I said, these entities that just generates all kinds of emotional responses. And you have to understand a couple things. Most homeowners associations have a set of bylaws that you must abide by when you buy into them. And those bylaws in many states are actually incorporated into the actual deed for your property, the title for your property. The thing that you have that shows that you own the property will often say, your property is within this association and bylaws are incorporated here. And it's an interesting relationship that you have there because quite often different parties enter into a contract. So, you and I meet, we agree on something, we sign a contract, right? There's a contract. This is a contract that gets entered into by people who are buying into the subdivision. And the contract, being part of the deed for the property, has different kinds of leverage than a typical contract. So if you and I enter into a contract and one of us breaches it, we run to court, we say it's a breach of contract, we want damages or something. Or we might run to court and ask for specific performance, asking a court to force someone to comply. But the contracts that they have here, the rules, the covenants, whatever you want to call them in your state, actually talk about what you have to do and what you cannot do. But it also includes remedies that they have. And the remedies might be fines of, say, $100 a day, but the remedies might also be that they can slap those fines onto your property as a lien and foreclose on your property if you don't pay. And that's the crazy part. And that's one of the things when people understand that, they go, wait, what? But you also knew that when you bought in. And the problem is that a lot of people go shopping for real estate. They go home shopping, looking at homes. They find a home that they love. This home is beautiful. I love this home. They go through the process and buy the home. And if you've been to a closing before, a closing will have, I just happen to have an illustration here for you. A closing will have about this much paper, okay? Yeah, these are show notes from previous episodes. It's happening in the pile here. But a typical closing will have about this much paper, okay? So you're going through all these pages at a closing, and usually give you like an hour, hour and a half for a closing. You could not read all of those papers in your lifetime if you devoted a full-time job to it. It just can't be done. It's pages and pages of mind-numbing one-point type. No one can read that. But amongst those things would have been a statement regarding the HOA. And so I can tell you that it's caused so much consternation in the last few years that now many places make you disclose that as part of the mandatory disclosures for property. Has the property ever been subject to flooding? Is the property in an HOA? Because so many people have said, I didn't see that. I didn't know that. But when you go into court and say that, the judge goes, okay, hang on a second here. Right there, isn't it your signature? Okay. Isn't that your signature? Okay, well, you signed it. That's how it looks at the other end. And so even if you go onto like Zillow and you're searching for real estate, one of the boxes you can check is no HOA because they recognize that's a search many people are doing on purpose. They don't want to be in an HOA. So keep in mind that when you move into someplace and there's an HOA, they got a lot of power. And I have spoken to people at both ends of the spectrum. I've had people tell me, they say, Steve, I live in an HOA, and if I am like washing my car, they come by and say, you're not allowed to wash your car there. Or I'm watering my plants and I drop the garden hose, go inside, and they come by, hey, you can't leave a garden hose in your front lawn. It's there for 3 minutes. You can't leave a garden hose in your front lawn. And I've known people at the other end to say, I live in an HOA, I wouldn't even know they existed. And it all has to do with the personalities of the people who are on the board. But it's stuff you've got to understand before you buy into someplace with an HOA. So whether this guy's going to win or not, I have no idea. And the reason is that what the court's going to do is read the rules. And the rules are not in full in this article. But he's going to read the rules and see what the rules say. It's a simple matter of that. But where it gets tricky is the rules are drafted by somebody. It's a matter of how well they were drafted. Because some of these HOAs, if they're built by developers who've done it before, are just simply using the same rules over and over again, and the rules might evolve. But if it's an old set of rules that were drafted a long time ago, somebody may have actually put in conflicting rules. There might be one rule that says you can, one rule says you can't. So don't know what to tell you on that, but my biggest takeaway here for you, if you wanted one, is if an HOA sounds scary to you, then when you go home shopping, don't buy into an HOA. And you could say, Steve, what if I talk to my neighbors? My neighbors, the future neighbors. They say, hey, we've lived here for years. We got no problems. Things change. I've also heard from people who said that they were living someplace in absolute peace and some crazy person got on the board with nothing better to do than drive around and look for violations. And I've heard it before where some crazy person was on the board and they moved to Florida and the HOA wasn't in Florida. And once that person was gone, everybody was happy. So there's a lot of unpredictability there. But here we have a homeowner and an HOA in court litigating whether you can place something on this side of the sidewalk versus this side of the sidewalk. And the other scary part about this, of course, is you're a member of the HOA. So when you are suing them, you're also paying their attorney fees through your dues. But another story altogether. Eric, Patrick, Joel, and Steve all sent it. When a ruling comes down, I'll let you know. HOA and homeowner in court over snacks for dogs. Joe Fisher wrote that for WRAL.com. Questions, comments? Put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. If you type Google into Google, you can break the internet. So please, no one try it, even for a joke.